Trump just got hit with civil contempt. Federal Judge Arthur Engoron has issued a ruling that will cost Donald Trump $100,000 per day until he complies with a court order to turn over financial documents in the New York civil fraud case. And this isn't some minor procedural ruling or technical legal dispute. This is a federal judge using the full weight of contempt powers to compel compliance from a former president who has spent months defying direct court orders. When a sitting federal judge bypasses warnings and moves straight to financial sanctions that accumulate daily, you know someone just crossed a line that cannot be uncrossed. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what triggered this extraordinary judicial action? According to court filings from January 28th, Trump's legal team has refused 17 separate requests to produce complete records of foreign bank accounts, offshore holdings, and certain real estate valuations that the court deemed essential to calculating disgorgement in the civil fraud trial. This isn't about routine document disputes or standard discovery disagreements. This is about a defendant who lost a major civil fraud case last September and is now actively obstructing the court's ability to determine what he owes. And believe me, when judges start imposing six-figure daily fines on former presidents, something monumental has just detonated. Here's the full picture of what's been unfolding. Tensions between Trump's legal team and Judge Engoron have been escalating for months, fueled by missed deadlines, incomplete document productions, and what court observers describe as a pattern of deliberate obstruction. But everything reached a breaking point on January 28th when the judge reviewed a confidential compliance report from a court-appointed special master. That report, filed under seal, documented systematic failures to produce court-ordered materials. According to sources familiar with the filing, the special master found that Trump's team had provided less than 40% of requested documents, with entire categories of financial records simply missing. The report specifically identified gaps in documentation related to properties in Dubai, a Scottish golf resort, and several limited liability companies registered in Delaware. This wasn't about disputing relevance or claiming privilege. It was about wholesale non-compliance with direct judicial orders. Smash that like button if this is making sense so far. Here's where it really gets serious. When Judge Engoron reviewed the special master's findings in chambers on January 27th, he immediately scheduled an emergency hearing for the following morning. Sources who attended that hearing told reporters that the judge's frustration was visible from the moment he took the bench. And let's be honest for a moment, contempt rulings against any defendant are serious. Contempt rulings against former presidents are virtually unprecedented outside of criminal proceedings. They don't happen over minor disagreements or technical violations. They happen when a judge believes a party is deliberately undermining the court's authority and obstructing justice. Here's what multiple sources say happened next. On the morning of January 28th, Judge Engoron convened a closed hearing with Trump's attorneys and representatives from the New York Attorney General's office. The session lasted approximately 90 minutes. According to two people present in the courtroom, the judge opened by reading specific passages from the special master's report aloud. He cited document request number 47, which sought complete banking records for all accounts held outside the United States between 2015 and 2023. The special master had noted that Trump's team provided statements for just 3 accounts, none of which matched account numbers that had appeared in subpoenaed Deutsche Bank records. Sources told CNN that Judge Engoron asked Trump's lead attorney directly whether his client possessed additional foreign accounts. The attorney responded that his team was still working to compile a comprehensive list. The judge's reply was immediate and sharp. "Your client has had 7 months," Engoron stated, his tone leaving no room for ambiguity. "This court will no longer accept representations about ongoing efforts. Either the documents exist and will be produced by close of business Friday, or your client will face financial consequences that accumulate every single day until compliance is achieved." Meanwhile, the Attorney General's senior trial counsel reminded the court that the outstanding documents were essential to calculating disgorgement amounts. She pointed out that without complete financial records, the state couldn't verify whether Trump had hidden assets or transferred wealth to shield it from court-ordered payments. By the end of that session, Judge Engoron had made his decision. He announced from the bench that he would be issuing a contempt order with daily financial sanctions. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely wild. At approximately 3:45 p.m. Eastern on January 28th, Judge Engoron filed a 9-page order that legal analysts immediately described as one of the most aggressive contempt rulings ever issued against a former president in a civil matter. The order doesn't mince words. It states that Trump is hereby held in civil contempt for willful failure to comply with lawful court orders requiring production of financial documents. The ruling specifies that Trump personally, not his corporate entities or legal team, will be fined $100,000 per day beginning February 2nd and continuing until such time as he produces the court-ordered materials in full. Reporters who reviewed the order within minutes of its filing say the language is unusually direct. Judge Engoron wrote that Trump's pattern of non-compliance represents a deliberate attempt to obstruct the court's ability to administer justice and calculate appropriate remedies. The judge noted that Trump had been warned repeatedly, given multiple extensions, and afforded every opportunity to comply voluntarily. He pointed out that the special master had made 17 formal requests. Each one met with either partial production, claims of inability to locate records, or outright silence. That's when it became clear this isn't just another legal setback. The bombshell moment came when Judge Engoron addressed Trump's public statements directly in the written order. He cited 3 Truth Social posts from January in which Trump claimed the case was a witch hunt and that he had provided everything the court requested. The judge wrote that these public assertions contradicted the evidence before the court and demonstrated what he characterized as either deliberate misrepresentation or willful ignorance of his legal obligations. Legal observers in the courtroom say that including this language in the formal order represents a judicial rebuke that goes beyond typical contempt findings. It's a judge putting on the permanent court record that Trump's public statements are factually false. This move sent shockwaves through legal circles. When a federal judge in a high-profile case uses contempt powers this aggressively, it signals one thing: patience has been exhausted and the court will no longer tolerate defiance. The claims of prosecutorial overreach or biased judges become much harder to sustain when you're being held in contempt for simply refusing to turn over your own financial documents. This isn't the first time judicial pressure has mounted around Trump's financial records. Think back to 2019 when the Manhattan District Attorney subpoenaed Trump's tax returns. Trump fought all the way to the Supreme Court, which ruled in July 2020 that presidents are not above the law. Trump ultimately had to turn over those records. Then there was the classified documents case. Federal prosecutors subpoenaed materials at Mar-a-Lago in May 2022. Trump's team certified everything had been returned. The FBI search in August revealed that was false, finding over 100 additional classified documents. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. Now, however, it's different. This time, a judge isn't just demanding compliance. He's imposing immediate financial consequences that escalate every single day. The pattern is clear. When defendants repeatedly defy court orders, judges eventually move to coercive measures. The system can't function if parties simply ignore judicial directives. So what allegedly triggered this unprecedented contempt ruling? According to legal experts who reviewed Judge Engoron's order, Trump's actions violated fundamental principles of civil procedure and judicial authority. The court has inherent power to compel parties to comply with discovery orders and produce relevant documents. When a party refuses despite repeated directions, the court must act to preserve its authority and ensure the integrity of proceedings. The order details systematic failures across multiple categories of requested documents. Court filings show that Trump's team failed to produce complete records for at least 12 foreign bank accounts, including accounts at financial institutions in Switzerland, the Cayman Islands, and Dubai. These weren't minor omissions. Sources familiar with the document requests say these specific accounts had been identified in earlier testimony and appeared in communications that Trump's own employees had produced. The judge found that Trump either possessed the records and refused to turn them over or had failed to maintain records he was legally required to keep. Here's the kicker. The order includes findings that Trump personally directed his legal team's document production strategy. The special master's report apparently contains email exchanges showing that attorneys had advised producing certain materials but were overruled. This wasn't lawyers making independent judgments about privilege or relevance. According to the court's findings, this was a client instructing his counsel to withhold responsive documents. That distinction matters enormously in contempt proceedings. It establishes willfulness, the legal standard required for sanctions. Don't go anywhere. The most explosive part is coming next. And here's what should alarm everyone. This isn't just about one civil fraud case. If defendants, especially powerful and wealthy defendants, can simply refuse to comply with court orders and drag out proceedings indefinitely, the entire civil justice system breaks down. The rule of law depends on parties respecting judicial authority even when they disagree with rulings. Once you establish that compliance is optional if you have enough resources to pay lawyers to file endless objections, there's no going back. Every other defendant will try the same tactics, and courts lose their ability to resolve disputes. This puts Trump in a nearly impossible position. On one side, complying with the order means producing financial documents that could reveal the full extent of assets subject to disgorgement in the fraud case. The Attorney General's office has argued that Trump owes over $400 million based on ill-gotten gains from fraudulent property valuations. Complete financial records might show additional hidden wealth, potentially increasing that figure substantially. On the other side, continuing to refuse compliance means paying $100,000 every single day. That adds up to $700,000 per week, $3 million per month, $36 million per year. Even for someone claiming to be a billionaire, those numbers become unsustainable rapidly, especially when you're already facing massive judgments and mounting legal fees across multiple cases. And here's the tricky part. There's no credible defense. Either the documents exist, in which case Trump is willfully withholding court-ordered materials to hide assets, or the documents don't exist, which would mean Trump failed to maintain financial records that businesses of his size are legally required to keep. That failure itself could violate banking regulations, tax laws, and corporate governance requirements. Both options are deeply problematic. Legal and political analysts are calling this a judicial escalation that could redefine executive accountability. Andrew Weissmann, former federal prosecutor and lead lawyer in the Mueller investigation, told MSNBC that the daily fine mechanism is particularly brilliant because it creates mounting pressure without requiring the court to immediately move to more drastic sanctions like asset seizure. He explained that $100,000 per day is significant enough to hurt, but not so catastrophic that appellate courts would be likely to grant emergency relief. It's calibrated to be coercive without being punitive to the point of being overturned on appeal. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even Jennifer Rogers, former federal prosecutor and CNN legal analyst who often provides measured analysis, called this ruling a game changer. She emphasized that federal judges rarely impose daily accumulating fines on any defendant, let alone former presidents. The fact that Judge Engoron felt this was necessary suggests he believes Trump's obstruction is so deliberate and so damaging to the court's authority that extraordinary measures are justified. Rogers noted that the findings of willfulness in the order will make it very difficult for Trump to successfully appeal the contempt ruling. So let's break down what this could mean. First, the immediate financial impact. At $100,000 per day, Trump will owe $700,000 after 1 week, $1.4 million after 2 weeks, $3 million after 1 month. If Trump continues to refuse compliance for 90 days, which is roughly how long an appeal might take to wind through the system, he'll owe $9 million in contempt fines alone. That's on top of the $83.3 million he already owes E. Jean Carroll from the defamation judgment, on top of the estimated $450 million he'll owe once the final disgorgement amount is calculated in the fraud case, on top of legal fees that are reportedly running into tens of millions across all his cases. The financial walls are closing in from multiple directions simultaneously. Second, it creates a massive credibility problem for Trump's claims of persecution. His entire legal defense strategy across multiple cases has been to portray himself as a victim of politically motivated prosecutors and biased judges. But contempt for failing to produce your own financial documents isn't political. It's not about prosecutorial discretion or novel legal theories. It's about a basic requirement to comply with lawful court orders. When a judge finds you in contempt, it means you defied the court's authority. That's much harder to spin as victimhood. You were ordered to do something straightforward, produce documents, and you refused. The narrative of witch hunt becomes significantly harder to sustain. Finally, looking at precedent, this is among the most aggressive contempt sanctions ever imposed on a former president in civil litigation. Richard Nixon faced subpoenas and judicial orders during Watergate, but those were criminal proceedings with different rules. Bill Clinton was held in contempt by a federal judge in 1999 for giving misleading testimony in the Paula Jones deposition, but that was after he left office and involved a one-time fine of about $90,000, not a daily accumulating sanction. Trump is facing something qualitatively different, an escalating financial penalty designed to compel immediate compliance with no end date until he produces the documents. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate legal impact, this is really about fundamental principles of judicial authority. The court system only functions if parties respect the power of judges to issue binding orders and enforce compliance. If wealthy or powerful defendants can simply ignore court directives by paying lawyers to file endless motions while never actually complying with the underlying orders, the system collapses. We're not talking about substantive legal disagreements or good faith disputes about privilege. This is about basic compliance with discovery and civil litigation. Every lawsuit requires parties to turn over relevant documents. If Trump can avoid that obligation indefinitely, what's to stop other defendants from doing the same? The implications cascade. This scenario is causing concern within Republican circles, though many are staying quiet publicly. Some argue for backing Trump's claims of judicial overreach. Others insist that being sanctioned for refusing basic document production makes that narrative untenable. The party is quietly divided. Meanwhile, Trump's base sees this as yet another example of the system targeting him. Social media is flooded with claims that the judge is corrupt. To supporters, this reinforces beliefs about a rigged system. Things escalated when Trump responded on Truth Social late January 28th. He called Judge Engoron a partisan hack and claimed he'd provided everything requested. Trump wrote he would never back down or comply with corrupt orders from corrupt judges, stating he would appeal immediately. Stay with me. What comes next will completely change how you view the situation. Here's what makes Trump's response even more extraordinary. By publicly declaring that he will never comply, Trump just made his legal position exponentially worse. Contempt is based on willfulness, a defendant's deliberate refusal to follow court orders. By posting that he will never back down and never comply, Trump has created powerful evidence of willfulness that the Attorney General's office can cite if they seek additional sanctions or if Trump tries to appeal. Judges reviewing the contempt order on appeal will now see that Trump not only failed to comply, but publicly announced his intention to continue defying the court. That's about the worst thing a defendant can do in a contempt proceeding. Legal experts immediately flagged the problem. Lisa Rubin, MSNBC legal analyst, noted that Trump's Truth Social posts are essentially contempt confessions. She explained that by stating he will never comply with what he calls corrupt orders, Trump is admitting on the record that his non-compliance is intentional and ongoing. Prosecutors can and will use those posts to argue that the $100,000 per day fine is insufficient and that the court should consider more severe sanctions. When your public response to a contempt ruling is to double down and announce continued defiance, you give the judge every justification to escalate. This goes far beyond one civil fraud case. It's about whether defendants, regardless of wealth or political power, must comply with lawful court orders. If Trump can successfully defy a federal judge, refuse to produce documents, and face no consequences beyond fines he may never actually pay, it sets a precedent that any defendant with sufficient resources can obstruct litigation indefinitely. That would fundamentally undermine the civil justice system. It's not just about Trump. It's about whether judges have meaningful enforcement power when wealthy defendants decide that court orders don't apply to them. If there are no consequences for this level of obstruction, every future defendant will test the same limits. Why comply with discovery if you can just refuse, drag out contempt proceedings, appeal, and delay for years? The entire discovery system, which is essential to civil litigation, depends on parties acting in good faith and following court directives even when they'd prefer not to. If wealthy defendants can opt out by hiring enough lawyers to file endless motions, access to justice disappears for ordinary litigants. If this blows your mind, hit that like button right now. Here's the situation. A federal judge has held Donald Trump in civil contempt and imposed $100,000 per day in fines until Trump produces financial documents he was ordered to turn over months ago. This is no longer about substantive legal disagreements. It's about whether a former president must comply with the most basic requirement of civil litigation, document production. When federal judges move to daily accumulating financial sanctions, we've entered territory that is genuinely extraordinary. If there are no consequences, it sets a dangerous precedent. Courts lose their authority to compel compliance, and the civil justice system becomes optional for anyone wealthy enough to outlast judicial patience. Keep a close eye on this story. More legal experts are weighing in on whether Judge Engoron will escalate to asset seizure if Trump continues to refuse compliance. Trump's legal team is reportedly preparing emergency appeals, though legal analysts say appellate courts are unlikely to grant relief when the underlying order is simply to produce documents. And attorneys following the case closely are watching to see whether Trump complies by the February 2nd deadline or whether the daily fines actually start accumulating. If Trump refuses to pay the contempt fines, that creates yet another enforcement problem, leading potentially to liens on properties or asset freezes. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand right now. A federal judge has imposed $100,000 per day in contempt fines on a former president for refusing to comply with document production orders. Trump has publicly declared he will never back down, essentially announcing his intent to continue defying the court. Meanwhile, the fines are set to begin accumulating on February 2nd, with no end date until full compliance is achieved. This isn't just another legal battle that will fade from headlines. This is a direct confrontation between judicial authority and a defendant who believes he's above court orders. What happens next could determine whether federal judges have meaningful enforcement power against wealthy and powerful defendants, or whether obstruction becomes a viable strategy for anyone with sufficient resources to pay lawyers and fines indefinitely. The evidence of non-compliance is documented in a special master's report. The order finding contempt is on the court record. Now we wait to see whether Trump produces the documents, appeals, and delays, or simply refuses to comply while the daily fines accumulate into the millions. The stakes have never been higher. The judicial authority has never been more directly challenged. And the question of whether rules apply equally has never been more urgent. Pause for a second and hit that like button if you're finding value in this coverage.